Other than the legal section, the contents of the file, hearing number 2128, as recorded by the CO, reveals that all subsequent correspondences, persuasions, and follow-up actions were being dealt with from this missing file. And since the case itself bears the claim of 70,35,994.16, the file was legitimately sensitive, claim custody, and careful handling, the CO himself did not at any point of time deny its importance and sensitivity. So there are some things, only for a moment, there are some documents, some aversion made by the inquiry officer. There is a proof that CO himself, the file is handling the missing file. That is the question. They have handled the missing file of 2188. The file was missing on the instant of the seal. It was also indicated in the inquiry officer's report. 4 on 4.5. Another thing may not, 4.7. Paragraph 4.7, page 53 will. Evidence on a portion of the charge that the CO was entrusted with the duty of monitoring the whereabouts of the instant file. Hearing number MS 2188, but remained totally silent about the movement of the file. 40 months without mentioning that date of placing the file and its movement is the first instance of the note of the CO under his signature marked as I or Exhibit P4. In fact, the entire para of the note under signature is the entire episode. It's not it decides yes after a few months without even going to the oral evidence. These note evidence to prove that CO did not monitor the whereabouts of the file and after remaining silent for a few months about the extent of the file without the note of Exhibit P4. Being the only state there's a duty to monitor the whereabouts of the instant file, follow and lay down procedure for filing especially when the matter was related to court cases containing FCI's claim for huge amount against the state. The reply to question number 27 during the right to testify, the silence has charged by the court to search out the file from various sections which does not by the case of reason as such his own note as referred to the movement of the whereabouts of the file was not monitored by the CO but also to lay down prosecution for movement of the file was not followed by him, which would have ensured proper track and safe custody of the file. Let's come to page 54-55. Para 5. Analysis of oral evidence of the written brief by the CO. Page 55 and reading may not. CO is in brief at page 7 under para 11.4 imagining and found besides the CO on which the CO prefer to reply on. As such, based on such conditions of the AMD cannot escape his responsibility to specify was not and I'm inclined to give version of
Oh, you are not. You come to page 92. Let the hearing of this case start from the page 92.
Page 92, my lord.
You are, both of you are not. What is the given? Considering the submission and considering the fact that the writ petitioner continued on suspension for a period of 15 months before the charge sheet was actually issued, I am inclined to remit the matter to the disciplinary authority to reconsider the matter insofar as the punishment restricted to the period of suspension is concerned. That means you kept him under suspension for 15 months without issuing a charge sheet. Whether that thing has been addressed by the disciplinary authority, so show us that that issue has been addressed.
Order 2004, probably 2004, not 2018, 2009. Order. That is seriously mistake. Second disciplinary order, may not annexed 14, page 92, 93. Kindly come to page 94. Page 94. The last paragraph below. Undersigned being disciplinary authority has considered carefully and this propriety and above submission of CO. And his letters dated 1423 2002 and 110/2002 were alteration of the submit subsequent allowed, which was already granted during the entire period of suspension from 2001 to 2003, and come to the conclusion that in terms of regulation 6671, the amount subsistence grant may be increased to a suitable amount, not exceeding 50% of subsistence grant admissible during the period of first 3 months since the suspension period was prolonged, and deemed it proper, justified to pass an order that specified herein. Thereafter, now therefore, 95 page below. Now therefore, the undersigned being disciplinary authority comes to the order dated 18/8/2009, passed with Honorable High Court, Calcutta. Hereby orders to increase the subsistence grants during the period of 3 months from 29/2001 till revocation suspension with effect from 2012/1 to 21/2/2003, not exceeding 50% of such grants already received by the Syndicate Staff, ex-AG2M, modifying the portion of the further direction of the penalty order 23 so and so, dated 24/3/2003, that declares that ADM 2M will not be entitled further to draw any amount in excess of the amount paid to him as subsistence allowed during the period of the suspension. Other terms of the penalty order dated so and so will remain same.
This order is totally silent about the delay caused in initiating the charge sheet after suspension, 15 months after suspension. Suspension order was issued on 28th of September 2001, and thereafter, Lordship, after 15.
That issue has not been addressed. So I am remanding back. Again, what can be done? Setting aside the order of the disciplinary authority, appellate authority, reconsider.
Can reconsider that can be done.
This present petition has been prepared to challenge the order dated 9th February 2010, passed by the disciplinary authority the petitioner joined Yes.
This is an application under section 401 read with 482, the old one. Under section 442 read with 528 of the BNSS Act 2023. Lord, what happened in these three orders were under challenge. In one order, my lord, your lordship would found that without applying mine in a mechanical way, the third public prosecutor who was appointed in the case, by dint of a honorable court's order, where the honorable court directed that the prosecutor may recall witness, if any, if he thinks fit. So on the basis of that, he filed an application for recalling of 18 witnesses without assigning any reason or without submitting any questionnaire to that effect, that what questions were left out and what are to be, my lord, what are the requirements for which the applications for recalling was filed. Second and third order, my lord, in second and third order, I will submit before your lordships the entire order. My lord, the first witness was examined and cross-examined. When the second witness, my lord, was examined, then, my lord, the learned PP in a, my lord, unprecedented manner, he went to the witness box and, my lord, loudly pressurized the the witness to say what he didn't spell out in the earlier, my lord, evidence in chief. So that was the reason, on protest, my lord, the learned lawyer didn't participate in the, my lord, cross-examination. Thereafter, the learned court, my lord, passed an order that is, since nobody cross-examined, is a deemed cross-examination. That is unknown to the, my lord, Code of Criminal Procedure and also the BSS. My lord, thereafter, in the second day also the same thing happened. And, my lord, applications were filed because of the, my lord, the unfair, my lord, the conduct of the, my lord, the prosecution, my lord, insisting upon the witnesses to say and to detract from the statement what he has said in the earlier examination in chief. My lord, there also, my lord, the same order passed that the learned lawyer, my lord, didn't cross-examine, so it is deemed to be cross-examined. My lord, on the earlier occasion also, my lord, one witness, that is PW9, he was not, his the cross-examination was deferred, but he was not yet cross-examined as yet. But the other witnesses are called up, and, my lord, other witnesses are examined and cross-examined. My lord, now, what happened, my lord, here, may I submit before your lordship the orders, because when it was felt by the learned judge, my lord, we even in the open court, my lord, uttered that I will see that how the accused is brought to book. And, my lord, that was the thing, my lord, which created, my lord, apprehension in the minds of the accused that I would be denied to fair trial. And, my lord, that is why the learned judge found that by this order the accused may assail before the honorable court for filing revisional application against the order. So, my lord, there are certain remarks, my lord, made by the learned judge against the learned lawyer, my lord, which do not get support from the application filed by the public prosecutor. My lord, had the learned, my lord, since 2021, my lord, the trial was on. 3 public prosecutors were changed. And, my lord, 3 learned judges, my lord, are in the session of the trial. So, my lord, there was not a single occasion where such thing happened, where, my lord, the learned advocate, my lord, on the situation which he faced, that, my lord, that the principle of, my lord, the criminal justice system that has been, my lord, denied, and the learned judge acted in bias, and the public prosecutor also proceeded in a manner which is, my lord, unusual. My lord, may I permit to submit the orders, my lord, which is under challenge. My lord, first order 5/2/2005. Today is fixed for production and evidence. Accused Nantu Josh. There are two accused, my lord. Learned lawyer for both the accused person present, special PV present, files Hajira of two witness, PW Rajimandal is examined in chief and cross-examined in full. On behalf of both the accused persons and discharged as PW 26. Written information, call book of Bolpur SD Hospital is marked as Exhibit 18 and endorsement thereof PW 26 is marked as Exhibit 18 by 1. Original receipt copy of intimation dated so-and-so addressed to IC Bolpur is marked as Exhibit 19 on proof of PW 26. The witness Gopal Chandra, retired SI of Bolpur PS, has been examined in chief in full as PW 27, and during his cross-examination, learned lawyer for the accused Profit Kumar Dotto left the court saying that he would not cross-examine the witness, and the court may do whatever pleases to do, raising misconceived, unfounded, and baseless allegations against learned special public prosecutor to the effect that learned special PP was threatening the witness in dock to depose in a particular way. The learned lawyer for the accused, Babun Josh and Nantu Josh, though remained sitting in the courtroom till completion of examination in chief of PW 27, has also declined to cross-examine the witness and left the courtroom. Thereafter, none has appeared to cross-examine the said witness in PW 27, Gopal Chandra, on behalf of the accused Nantu Josh, Babun Josh, and Pravit Dotto, on repeated calls for the reasons best known to them, and accordingly, in the interest of justice, the cross-examination of PW 27 is deemed to be declined by defense, and accordingly, the cross-examination of PW 27, Gopal Chandra, stands disclosed. My lord, your lordship knows well that in the case of, my lord, when any lawyer, my lord, leaves the courtroom and the accused, my lord, should be asked whether he wants the help of a lawyer from the legal aid committee, or rather he wants to cross-examine himself. Because if the conducting lawyer leaves the room and, my lord, he, for certain reasons, for his objections, since being not entertained by the learned, my lord, trial judge, if he leaves the room, it is the onerous duty upon the, my lord, learned trial judge to either to provide him a legal assistance or to, my lord, ask him whether he personally intends to cross-examine. That was not done. Without doing so, my lord, the order is that deemed cross-examine. Then, my lord, the next order. Today is fixed for production, so-and-so, learned counsel for the accused. Pravit Dotto has appeared before the court in the forenoon session after filing 3 separate petitions. He left the court stating that he is going to other court to conduct proceeding in other matters. Since then, he had to return before the court to move the aforesaid petitions. Learned special PP is present and Hajira one witness. He also files the written objection to the petition of the learned counsel of the accused, Pravit Kumar Dotto, 5/2/25. Learned special PP has also filed 2 separate petitions, one for exhibiting the FSL report, so-and-so. But in course of hearing, learned special PP not pressed the aforesaid 2 petitions, and accordingly, petitions for exhibiting FSL report and exhibiting the confidential statements of the witnesses stands rejected at this stage of proceeding, being not pressed. Now, the petition of learned counsel for the accused, Pravit Kumar Dotto, dated so-and-so, is taken up for hearing along with 2 other petitions dated 6/2/25. Learned counsel for the accused, Pravit Dotto, is not available at the time of hearing of the petition. Learned special PP submitted that he had received the copy of the said petition of defense at about so-and-so and court hours after completion of the day's hearing of the instant case. Learned special PP has submitted that learned defense counsel appear for the accused has made some wild and false allegations against him as well as against this court in this petition dated so-and-so, just to delay and derail the proceeding of this case and to intimidate and influence the witness and tamper the evidence, which he is doing all through since inception of the proceeding of this case. Learned special PP submitted that the learned defense counsel has not done for the first time rather he has done the same thing to disrupt the proceeding of the case on previous occasion of the time for further examination of PW9. My lord, what I was saying, that PW9 is still remain uncross-examined. But Biru Barui on recall on 8/2/2024 and a special PB submitted, the learned defense counsel had left no stone unturned to delay and derail the trial and to defeat the justice for the decision's victim who had died in the custody of the accused person. Learned special PB has further submitted that the instant petition of defense for accused Prabir Kumar Datta are all false, fabricated, whimsical, without any merit, and same is liable to be rejected to protect the sanctity of the court and judicial system. I have perused all the 3 petitions filed by the learned defense counsel appearing for the accused Prabir Datta. It appears that the learned defense counsel have raised some wild, motivated, fabricated, false, concocted, and contemptuous allegations against the learned special PP as well as the presiding officer of this court in the petition dated so. It further appears that the instant petition of defense counsels for accused Prabir Kumar Datta is primarily directed to disturb, delay, and derail the proceeding of the instant case. It further appears from the record that the attitude of learned defense counsels have occurred not for the first time on 5/2/25, but on the previous occasions, that is on 8/2/2024. Learned defense counsels have done the same thing, raising wild allegations against the court, and to disturb and delay the proceedings, they have left the court, and finding no other alternative, this court was constrained to close the cross-examination of PW9 on the said day, that is 8/2/2004. The approach adopted by the learned defense counsel for accused Prabir Kumar Datta is quite unethical and disturbing one. Same is also against the judicial discipline and affecting the smooth functioning of the court. Considering all aspects, I find no merit in the instant petition dated so. Accordingly, the same is rejected. The other 2 prayers so for defense accused are also misconceived, motivated one, and accordingly the same are also rejected. The case record is taken up for hearing. A recording of evidence. Prosecution witness so is present. The prosecution witness so, the examiner question documents is examined in full and cross-examined in full by learned counsel of accused Nantu Josh. Learned defense counsel for accused Prabir Datta have not appeared to cross-examine this witness, and accused Prabir Kumar Datta, who has been produced before this court through VC from Part-1 Central Correctional Home, has also declined to cross-examine the witness in person. Under the said circumstances, the cross-examination of this witness on behalf of accused so has deemed to have been declined. Then on proof of so and exhibit so and on completion of examination, the no other witness is present. On consent both the parties, the following schedule is made. Summons are, my lord, there are 43 witnesses. My lord, this is the witness number PW 2829. My lord, not a single occasion occurred in the past where, my lord, such thing happened. And my lord, after joining of this learned public prosecutor from Howrah Court, he took the advantage of the order of the Honorable Court and filed applications for recalling of 18 witnesses without assigning any reason. My lord, I am referring to that. And before that, my lord, the observations of the learned magistrate and the objection filed by the petitioner and the, my lord, counter objections filed by the learned public prosecutor in order to find out the truth, whether there was any misdemeanor on the part of the learned advocate or whether he is the right to object. My lord, if anything goes, my lord, against the principle of law, against the principle of criminal jurisprudence, then whether he has a right to do so. And for that, all these remarks were, my lord, made. My lord, we request to be expunged for the ends of justice, because there was nothing happened in that sort. I will show your lordship. My lord, if your lordship kindly turn to page 33, the objection, my lord.
Yes.
In connection with the case, the accused petitioner most respectfully swears that today on 5th day of February, the case is posted for evidence. Witness Mr. Rajiv Mandal is examined in full and discharged. And then another witness, Gopal Chandra, my lord, for the first witness who was examined and cross-examined, there was nothing, my lord. The conduct of the public prosecutor is also fair, and we didn't object. Then when, my lord, this second witness, Gopal Chandra stepped into witness box in cross-examination, examining being asked by the learned public prosecutor. The witness answered twice, which seems to be against the prosecution case with regard to the identification of the accused petitioner. And the learned PP stepped in the witness box and extra-legally in very loud voice by pressure compelled the witness to answer in support of the prosecution case. And learned PP standing beside the witness, his witness box on his behalf, gave deposition on behalf of such witness, which is extreme opposite to the concept of fair trial. The learned lawyer protested severely of such extra-legal conduct of learned PP and tried their level best to bring the same to the vision of learned court, and with folded hands prayed interference of the learned court, but the learned court turned deaf ears to the submission of the learned lawyers of the accused, and the learned court ignored and closed his version for the reasons best known to him. Thereafter, finding no other alternative, the lawyers represented the accused petitioner is in helpless condition, with due respect, compelled to leave the courtroom. Thus, the accused petitioner thinks that he has been depriving from getting fair trial and unable to exercise the constitutional rights to defend themselves. Thereafter, the accused persons came to learn that the learned PP examined himself on dock and gave deposition on behalf of such witness. And the learned court, ignoring all pleas to decline the cross-examination, thus your accused petitioner unable to take part on trial and no such opportunity granted to them. On sitting on the chair of the learned court, advised to bring the all witnesses tomorrow. On closing the evidence, learned court shall pass the judgment of the case against the accused petitioner. Thereafter, he will see what the accused and their lawyers can do anything against them all. The accused petitioner, in his extreme fear, and they apprehend that the case is already pre-decided, the accused petitioner will think to take refuge before the mighty pillar of justice, before the Honorable High Court, Calcutta, with a prayer to transfer the case to any other court so that they can able to get fair trial and thereby they be able to establish their innocence as before this learned court. They are unable to exercise their constitutional rights. That situation so prevailing, following such out of fear, the lawyers unable to proceed with the case anymore, otherwise they never have any intention to leave the courtroom. It is pertinent to state herein that the accused persons are not produced before the learned court, and the conduct through video also lacking, and prosecution never supply witness list as to in which witness bring by them for examination, that this application is made bona fide. My lord, this is the practice nowadays. Because in a criminal trial, your lordship has seen so many cases that as per the charge sheet, schedule is being prepared by the learned public prosecutor and submitted before the court that on such and such day, he wants to examine the such and such witness as per CS. But the practice is going on here also. The practice is there that no such application was filed by the learned public prosecutor in order to put on record that which witnesses are to be examined on the next day. Thereafter, my lord, it was replied by the prosecution. And from both the petitions, your lordship can guess that how the learned trial has acted in a manner, my lord, which is prejudicial to the interest of the accused. My lord, justice is not only to be done, but it seems to have been done. The written objection, that is page 34, your lordship. That the learned public prosecutor received a copy of the application dated so-and-so, filed on behalf of the accused persons, Pravit Dotto, at around so-and-so in the evening after court hours, and he denies and disputes the allegations made against him in the petition submitted by the learned defense counsels. That the learned special public prosecutor categorically denies any form of misconduct or undue pressure exerted on a witness. All questioning was conducted within the established legal framework, thereby maintaining the integrity of the judicial process. That the prosecution is steadfast in upholding the principles of a fair trial. All procedures adhere strictly to the legal requirements, ensuring the rights of the accused were respected throughout the proceedings. That it is clarified that the examination of witnesses was conducted in strict accordance to legal standards. Any statements made by the witness were their own, free from influence or coercion by the prosecution. That the court has consistently maintained its neutrality, showing no bias or particularly towards either party. The judge has acted within the bounds of judicial propriety, ensuring a balanced and impartial hearing. That the defense has afforded the opportunity to cross-examine witnesses if they choose not to do so. This decision was made of their own volition and not due to any obstruction by the prosecution or by the learned court. Moreover, the learned court waited till 5 p.m. for the learned advocate for the accused persons, but they didn't return. That on previous occasion also learned advocates representing the accused persons left the learned court while proceeding of the instant matter was being taken up and heard. The prosecution humbly submits that this kind of conduct is a delay tactics which is not at all appreciated. That the accused were present in the courtroom or participated via video conferencing following standard legal procedure and ensuring their right to be present during the trial. That the prosecutions provided the defense with a list of witnesses in accordance with legal requirements, allowing them ample time to prepare for cross-examination. That any allegation against the learned judge's conduct are refuted. The learned judge has acted with integrity and in accordance with judicial ethics, ensuring a fair and just trial process. That the request for transfer to another court lacks merit. The current court has demonstrated fairness and adherence to legal
Okay,
standards.
I have understood.
My lord.
Your fear is that you want now a direction so that you can cross-examine those evidence.
Those
Witness PW9 such and such.
W9, 26, 27.
But record reveals that you left the court.
My lord. And that is not without any cause and reason.
It is very unfortunate.
Very unfortunate.
No, your defense counsel conduct I am
My lord,
pointing
my
out.
lord.
I am highlighting.
My lord, what to do? Because he
Tell
cannot,
Mr. whether court
cannot
said
defend.
call for.
my lord, let
An
me,
advocate is an officer of the court.
my lord, that I bow down before
Okay.
your lordship.
He is not here to somehow win the case given by his
No,
client.
no, that is not the case, but it is his onerous duty also to see
And
that the trial
look,
is going on in a
look,
manner.
you from the conduct I have read, just now I have read from the conduct, your defense counsel conduct is not good.
Right.
From the order and even from his own application, it is not appearing here a little respect to the court also.
My lord, your lordship kindly
It is an
appreciate.
institution.
My lord, your lordship
Due
kindly
to one person, one defense counsel, the dignity or majesty of the institution cannot be allowed to be lowered down.
My lord, that should not be, that is not the, my lord, the attitude of the
He
learned
has
judge.
left the court.
My lord, he has left the court because
One
objection, my lord, persists.
division bench of this court granted liberty
Right.
to the special to the prosecution
Right.
to recall the witnesses.
My lord, recall of what witness? So all the
Witness,
witnesses.
the order by which the recall was made has not been challenged in this.
My lord, yes, it has been challenged.
It is not the subject matter of
It has been
that.
challenged, my lord.
Now that was recalled.
My lord.
That order you have not challenged.
My lord, that order has been challenged. Your lordship kindly see.
Why that
Cause
order?
title,
That
cause title
recall,
kindly see.
Cause
Cause title kindly see.
and that order, how that order can be said to be bad,
My lord,
which has been passed in compliance with the division bench of this order.
that I am to satisfy your lordship.
Okay, that apart, that
My
is
lord.
not your prayer.
My lord,
That is not your prayer.
my lord, kindly see the order passed by Justice Miller.
And you hear, and the personal observation by any court cannot be subject matter of a challenge.
My lord, that
No way.
my lord, that observation, if that observation is not in conformity with the Miller situation and also the petition and the counter petition of the learned public prosecutor, your lordship can very well assume that since in the judge's mind it was there that he may prefer revisional application before the High Court. That I have stated in my petition. And that is the reason all were Miller recorded.
Dispute started regarding identification of the accused person by a particular witnesses.
Who has not identified in the
It
evidence
was,
in
it
chief.
was your defense counsel stand that he initially refused to identify the accused person from the dock. Then it is the PP who rebuked him and shouted at him, and then he changed his stand, and then he identified, yes, this is the
My lord,
person.
he can be
This
permitted.
court started.
Well-
Thereafter, after completion of examination of the witnesses, maybe on recall or maybe at the first time, you have left the court.
My lord, that is the reason if
You
the
have left the court.
my lord, I am representing the accused. I am not representing the learned advocate. I am asking myself, my lord, whether a fair trial is to be, my lord, my lord, principle of, my lord, the criminal justice system.
No, that
Because-
acceptance of your power
Because
would be
if
would be
my,
given an indulgence to such sort of
my learned,
advocate.
I'm learned lawyer on filing certain objections, my lord, against the conduct of the public prosecutor. If he, my lord, goes out of the court, then, my lord, is it not the onerous duty of the learned trial judge to give an opportunity to the accused that you cross-examining? Otherwise, I am giving you the
Go on.
legal assistance.
Go on, the Learned Defense Counsel will leave the court. And what do you want?
My lord, what is the fault
The
of the
judge will
accused?
go to the room.
My lord, what
Then
is
you
the
please
fault?
come.
My lord, no.
Huh? What do you want?
I am not asking that. What I am submitting, that the accused must be, my lord, asked by the trial court.
However, a court, either in appeal or in revision, it is hard for any court to sit either in appeal or in exercise the power of revision in respect of a personal observation regarding the incident occurred in a court.
My lord, then there are so many advocates, my lord, who are present. They can file affidavits that such thing, such misdemeanor was not happened.
Okay,
This was done.
what
My lord,
prosecution?
kindly come to, my lord.
Okay, I have read. You have made some wild allegation against the court also,
No,
as well as the special PP,
my lord, special
against all.
my lord, I'm showing you, lord.
And don't think that only the criminal law
My-
are only to support the accused person.
No, my lord.
Criminal law
I am
only
not
to
on that.
honor
I
the
am
truth.
not on that. I am also senior
A
advocate.
trial is
I
a
have never, my lord, ask or rather give any, my lord, suggestions, my lord, to disrespect the court. My lord, court is above everybody because this is the institution where we have to bow down before the court and to, my lord, proceed for the interest of the litigants, not to lord, not to entangle themselves into any controversy. But where, my lord, such thing, my lord, kindly see, since 2021, evidence is continuing. My lord, there are 3 judges who are, my lord, transferred.
okay.
My lord,
Okay,
my lord, one thing I'm referring, your lordship says that by dint of High Court's order, when there is an order of recall, so, my lord, he got the right. He got the right to examine whatever witnesses, whomever he may be. He is to be recalled. My lord, kindly see the order. My lord, this is the order of the, my lord, Division Bench of Justice Bagchi, my lord.
Yes.
Legal remembrance, sir. This is the order, my lord, 10/8/2023. That is page 23, my lord.
Yes, 24.
My lord, 24, yes.
Page
Legal
24.
remembrance, sir, is directed.
It shall be open to the special public prosecutor to recall prosecution witness,
Witnesses,
if any, for a just decision of the case.
if any, for a just decision of the case.
That this court cannot touch this portion of this order.
My lord,
This court.
my lord, No,
They say,
no.
I cannot touch.
my lord, I am not on that.
I cannot touch. Yes.
That whether the, my lord, exercising the power under section 439, my lord, court can exercise the power of revisional power also by directing.
Go to Supreme Court.
My lord, that is another thing. I am learning, my lord, I am learning. And that's why, my lord, kindly see the applications for recalling. My lord, my lord, what is 311? Kindly see, my lord, for a moment. What is 311? Not in the way, my lord, they have done so, that is permissible under the law. It is the power of the learned trial judge. It is the power of the learned court. 311, power to summon material witness. Related page 25, my lord, where the applications for recalling was made. And this way, recalling cannot be permitted until and unless the questions which are to be put to the witness, those are to be, my lord, submitted and copy of those to be given to the defense lawyer. That is the way, my lord, how to, my lord, recall a witness. But in such a manner, it cannot be permitted. My lord, 311, power to summon material witness or examine persons present. Any court may, at any stage of any inquiry, trial or other proceeding under this code, summon any person as a witness or examine any person in attendance, though not summoned as a witness, or recall and re-examine any person already examined, and the court shall summon and examine and recall and re-examine any such person in his evidence appears to it to be essential to the just decision of the case. My lord, that should be reflected in the consideration of the learned court, because the honorable court directed that if any liberty is given to the public prosecutor to recall any of the witness, but he is to satisfy the learned court by filing an application against each and every witness, that why their recalling is necessary for elucidating the truth, or for, my lord, what has been stated to be essential to the just decision of the case. Now, whether that has been done,
That is two part. One part may based on the application made
based on
by
the
the
application,
prosecution, and the last part is shall.
shall
Shall means when court will come to a conclusion
yes,
that his recalling is necessary.
I am on that. If
Okay.
your lordship kindly see the application, my lord, page 25.
18 witnesses were recalled. Okay, 18 witnesses recalled. Now you cross-examine the rest all, only PW 9, PW 7, 27, and PW 28. You left the court, didn't cross-examine. Then in respect of other 15 witnesses, you cross-examine.
My lord, I cross-examine.
Yes, that means you accepted this
My
order.
lord, that is, my lord, before this highest majesty of the honorable court, my lord, I have every right to draw the attention of the learned
So a
court.
major significance.
Whether trial is proceeding in conformity with the procedure laid down, because the power has been vested by the statute.
Most probably I am not clear.
But your lordship is saying what I understand, my lord, that since you took part in the cross-examination, you have waived your right. My lord, but law stands in its own position. Law says that if the learned magistrate found that each and every witness, their recalling is essential for the jurisdiction of the case, then that's a different thing. And moreover, the witnesses who were examined, cross-examined, or declared hostile, if they are, my lord, again to be recalled, then, my lord, the learned prosecutor is duty-bound to submit a questionnaire, that what questions are left out to be put before the, my lord, the witness for his further examination.
Where from you are getting so?
My lord,
Where from you are getting so?
the procedure, my lord, we are seeing for, my lord, the decades.
Oh,
And, my lord, in the case of recalling of the witness, my lord,
a questionnaire is to be handed over. Where you have got
my
this?
lord, beforehand it is to be given to the.
You find out any provision from
My lord, that I will show your lordship.
that
I will show you.
questionnaire is to be submitted,
My lord,
then the witness will be
my
recalled.
lord, it cannot be in the manner which have been done, because if your lordship kindly see his application, page 25, and the witness list, and my lord prayed that the court may be pleased for recalling of the order. And my lord, what is the order of the learned judge? Kindly see. Where is that? Section 311 was, my lord, complied by the learned magistrate. And there is any, my lord, the learned judge says, heard both sides on the petition dated so and so of the prosecution under section so and so 311 for recalling the prosecution witness from PW 3 to 6, PW 8 to PW 12, from PW 14 to 21, PW 24, total 18 witnesses. Learned papers, special PP submits that in view of direction of the Honorable Court, he needs to recall the 18 prosecution witnesses for further examination in the interest of justice and fair trial. Learned lawyer of both accused persons oppose the prayer in view of the direction so and so. For the interest of proper adjudication and fair trial, the prayer of prosecution for recall of witness is allowed. This is the order of the learned magistrate for allowing the recalling prayer for 18 witnesses. Thus, the learned judge, my lord, has gone through the provisions of section 13, or rather considered that their examination or re-examination is essential to the just decision of the case, where the learned judge has applied his mind. If that is not done, that is against the the principle, that is violation of principles of natural justice, that is violation of the provisions, and also on this aspect, my lord, there are so many decisions of this Honorable Court and also the decisions of the Supreme Court that where and when the learned judge, if allowed such prayer, he should be circumspect and cautious before, my lord, because this is not the court who is, my lord, during the course of the trial found that this person is a material person who is to be produced before the court and his deposition is to be recorded to elucidate the truth. This is not that. This is at the instance of the prosecution. And prosecution, my lord, they are not a privileged litigant, because the defense, the accused who is facing trial, my lord, he must be given all fair opportunities, because the prosecution cannot go in their own way. They must be guided by the laws of the land.
Okay. Allow the prosecution. Yeah. Yes, Mr. Roy.
My lord, 3 orders have been assailed before your lordship
Hmm.
in a single petition. First of the order is dated 16th of December 2023,
Hmm.
which admittedly is barred by limitation. Now, so far as your lordship has seen, his main grievance, if I can understand, is that he doesn't have a friendly prosecutor at the trial court now. Previously, he had 2 friendly public prosecutors, but this time at the intervention of this honorable court, he doesn't have a friendly prosecutor.
May I object, your lordship?
You go on objecting. My lord, your lordship will now kindly come to
Yes.
page 6, paragraph 9 of his petition, here before this honorable court.
Page 6, paragraph 9.
9. How has he been prejudiced by this 311?
Yes.
He says the same questions which were earlier put were being again put. So this is wasting the court's time. His right to speedy trial has been left out. If your lordship sees his petition, it is basically on the ground, apart from that identification part, that he has a right to fair and speedy trial, which is being violated in this case. My lord, again, your lordship will see paragraph 14 at page 8.
Yes.
This paragraph 9 before your lordship's court does not say that he has been in any manner prejudiced or there has been filling up of the prosecution case by this re-examination. My lord, he says, I take objection, he didn't have a friendly prosecutor, but this High Court has observed that he had a friendly public prosecutor. If your lordship now again comes to paragraph 17.
Yes.
I'm not going to that. He is saying basically it had to be done on a, now your lordship will, 311 we have done with. Now your lordship, he files an application which was objected to. He says, the application is appearing at page 33. Is filed by the learned advocate, not the petitioner before your lordship, although the petitioner was present before this court. Now, this has been referred to in paragraph this has been referred to in paragraph 11. If your lordship kindly comes to page 7 of the revisional application. Now your lordship will kindly come to page 17 of the revisional application. This purportedly is true to the knowledge of this deponent, who is the well-wisher of the petitioner, who stays in Lake Town. So the petitioner comes from a different part of the city altogether. I do not know how it could be true to his knowledge. My lord, your lordship has seen from the order, there were some, I can demonstrate to your lordships that there is an observation that it is not the case that the prosecution was also not at fault for the delay in the trial. If your lordship kindly comes, there were some laches, it was admitted by the state before this honorable court. Page 21, paragraph 2. There was delay. But the major part of the delay, whatever it is, was due to this. Now, my lord, he says, as the learned advocate for the accused persons left the court, it was the duty of the court to call upon him whether he wants a state defense. My lord, that is the case when he is not represented. My lord, on the next date, the same lawyer appears. It is not that the lawyer had recused himself. The very same date his lawyer appears, he files a petition. With respect to the learned lawyer, who is the counterpart of my learned senior friend, the conduct is not good. He could have said before the court, I am objecting to this recording of the evidence. What it is done, objected to. This is a case of custodial death. He who was supposed to protect the law has violated the law. He was the inspector in charge of the Bolpur police station where the incident took place, at his instruction, at his presence. Your lordship sees the other accused person's advocate was present in the courtroom all throughout. He also chose not to participate. What will the court do? As it fell from your lordships, the court will rise and go with an invitation card. Please come, please come. Well, the last witness is being examined. So far as the recalling is concerned, 311, it has not caused any prejudice to him. It is his case that because of this recalling, there has been a delay. Your lordships can do that. 13th and 14th is the date fixed in the trial court. Your lordship can direct the trial court to complete the trial as expeditiously as possible. Last witness is going on. Hopefully, my learned friend will not delay it by examining 38 defense witness. Your lordships can, his grievance, this recalling has caused him prejudice because the trial has protracted. Your lordships can take opposite steps by directing the learned trial court. Now, so far as these applications are concerned, my lord, let's set the better, my lord. Your lordship sees the last order. The learned judge has observed why these applications were being filed. It further appears that the instant petition of the defense counsels for the accused Prabir Kumar Datta is primarily directed to disturb, delay the proceeding of the instant case. It further appears from the record that his attitude of learned counsels have occurred not for the first time on such and such, but on previous occasions too, that is on such and such. The learned counsels have done the same thing, raising wild allegation against the court, and to disturb and delay the proceedings, they have left the court, and finding no other alternative, this court was constrained to close the cross-examination of PW 19. His good senses prevail, your lordship. I am not saying that. If his good senses prevail and he wants to participate in the trial, your lordship can give him a date on that schedule to cross-examine PW. এটা বন্ধ করে দিল। আরে ব্যাটারিটা ফাঁসি মুরগি ছাড়া কিছু জানেন। ওটা তোমরা অপদার্থ বলে এটা তোমাদের করে জজ সাহেবরা আনতে বলেন রিপোর্ট।
Is 27 and PW 28. Most probably, I am
Yes, ma'am.
ascertained from the record also.
PW 28. 28. My lord, page 38. Go to the certified copy. PW 27 and 28. Although I'm not conceding to, I'm not conceding to that. But if the good senses prevail, your lordship can give him a chance.
My lord, two things I will
Produce the witnesses on that.
It would be given an indulgence to an
Yes.
unruly lords.
My lord, I'm just, my learned friend is blaming me.
You have to think that it is a institution
Right.
and its dignity cannot be lowered down at the behest of one particular.
I bow down, my lord, I have deepest respect to the court.
Basically, some
Only-
person are taking case, they have no capability to cross-examine
And
witness
even my lord, say-
ready to say
my lord, that
against
is
the.
one part. That is one part. Another part is public prosecutors are appointed who are also, my lord, lacking all these expertise to handle the, my lord. I am showing two things, your lordship, for your lordships, because my learned friend has,
Okay, court has seen. Court
my
has
lord,
seen.
my learned friend has, my lord, blamed
It's
me.
unfortunate only to defend one case.
My
If,
lord,
if one learned advocate,
My
You,
client,
Mr. Rai,
I got your
consider one learned advocate while handling a case,
my lord,
is handling in such a way, he is giving aspersion and wide allegation against the PP. He is giving aspersion wide allegation against the court
my lord,
again and
he
again.
has not done so.
That means
He has not
unable
done
to
so.
handle
What?
the court.
There are a number of lawyers who are present inside the court.
The
That was
presiding,
not even
presiding
happened.
officer is enemy.
And
to-
my lord, there was no friendly, my lord, public prosecutor, no friendly public prosecutor. We are not at the mercy of the friendly public prosecutor. And my lord, had it been, then my lord, 24 witnesses could not have been, my lord, examined earlier. And moreover, my lord, what I would draw your lordship's attention that I am not responsible. I can show your lordships in the second half.
Okay, court, you kindly, you consider now regarding merit the scope of the matter.
Fine.
This court, I have stated, excuse repetition, I have stated this court cannot nullify or cannot set aside the order passed by Honorable Division Bench. The Honorable Division Bench granted liberty to the prosecution to recall the witnesses. You have not challenged
If
that portion of the order.
if any.
You have not challenged that portion of the order. That order of the Honorable Division Bench is binding upon the learned court.
Right.
Similarly, it
But
has a binding effect upon this court
Not in
also.
a closed mind. The
Okay.
learned judge,
Had accepted the
the
order of the
onerous-
trial court also.
my lord, the
He had
onerous,
participated in the proceeding.
my lord, one-
You have
one-
participated. Prosecution expressed its intention to recall 18 witnesses.
my lord,
You have cross-examined all 15 witnesses.
my lord.
That means you have significant portion of the order has been accepted by you.
My lord.
Now you are again challenging.
My lord,
While now some dispute cropped up regarding cross-examination of 3 witnesses only. And the conduct you have
since my learned friend says, what-
demonstrated.
what
during
we
the
used to
trial
do, my
is-
lord, what we used to do when we practice in the, my lord, trial court, my lord, what learned friend says, that we ask the learned court to, my lord, record objected. My lord, if the learned judge is acted in bias, he doesn't, my lord, consider the submissions of the learned defense lawyer, even what happened there, my learned friend also do not know. I also do not know. Because what happened, my lord, my learned friend says that due to me, the trial has been delayed. Kindly see page 24 for a moment.
It is the observation of
Kindly,
the
no,
division
my lord.
bench.
My lord, I can,
Headed by Justice
my
Banerjee.
lord, I have document
That
on the,
delay also can be attributed to you, to
No,
the
my lord.
defense also.
my lord, here kindly see for a
I
moment.
cannot
Page
touch this
24.
observation.
No, my lord, that your lordship, I am not asking. What blame was given, that your
No,
lordship.
no,
kindly-
yeah, forget about the blame.
My lord, kindly see. Before parting, we note the lackadaisical manner in which the prosecution has been conducted by the public prosecutor. He did not examine vital witnesses properly. This is not friendly law, my lord, public prosecutor. Only their statements before magistrate were exhibited. I do not know how 161 statements were made exhibited. What is the law under the code? This is a clear dereliction of duty on the part of the public prosecutor to conduct the trial. So, my lord, situation is different. I have all the certified copies of the orders. 30 days, the public prosecutor didn't present in the court. 30 days. In spite of the direction of Honorable Justice Bosak, in spite of the direction of Justice Arijit Banerjee, in spite of the order of Justice Milord Joymallo Bakshi. Milord, 30 days the public prosecutor remained present, and Milord, there are so many dates when no witness was present. And moreover, kindly see my learned friend's submission. Milord, kindly see page 21. We find the suggestion, that is the order, Milord, 19/6/2024. We find suggestions of the learned APP to be reasonable. The charge is serious. We are not inclined to release the petitioner on bail. However, we direct the learned trial court to positively conclude the trial within 3 months from the date of communication of this order by the parties to the learned trial court. No unnecessary adjournment shall be granted to either of the parties. Both the parties shall fully cooperate with the trial court in bringing the trial to its logical conclusion within the aforesaid time period. In the event the trial is not completed within the time period of 3 months as indicated above, the petitioner will be liberty to renew the prayer for bail. This is in the month of June 2024. and we filed applications in October 2024. And his determination changed, and the other division bench, my lord, did not give any credence to the order and rejected my bail. And I have filed
And
SLP.
thereafter, this
And
is-
I, no,
and
no,
thereafter,
thereafter,
this
I
is another
filed,
application.
I filed the bail
Order has
application.
not been.
My lord, I
order has
filed the
not
bail
been annexed to
application
your lordship.
before the Supreme Court, and the Honorable before the Supreme Court, the bail application is pending on 2nd May 2025. So my learned friend says that because of that I am doing this, that is not
Order
the
is
case.
not annexed to your lordship's brief, though it is affirmed on 27th of February 2025.
And there was a direction for expeditious disposal. So no need of that, the court will ask for conclusion of the trial.
Court has said that the prosecution is acting in a diligent manner.
My lord,
Oh, okay, yes.
that is there and here also there.
It has not been annexed, this order?
Though it is filed on 27th of February 2025.
Justice Bosak,
Justice Bosak's order?
my lord, that, my lord, my,
So give a copy. So it is
only
115, okay, hard আপনি ইয়ে করুন তো হার্ড দ্য লার্নেড অ্যাডভোকেট অ্যাপিং ফর দ্য রেসপেক্টিভ পার্টিস সবাইকার নাম লিখে দেবেন ঠিক আছে আচ্ছা 22 ঠিক আছে on 22
Well-
under the heading for orders.
as your lordship.
This on Wednesday, subject.
Huh?
That is a part of the status report. Your lordship can, I am filing it for the courts.
আচ্ছা আচ্ছা status report filed on behalf of the state. হ্যাঁ আচ্ছা
Kindly take this on
Huh?
Wednesday,
leave the
22nd.
court. Huh? Everything. Item number 20.
Yes. My lord, 22nd.
Not today, only not
My lord,
today.
22nd, my lord. Monday, I have some personal difficulty. my lord.
Okay, 22nd.
My lord,
Okay.
my lord, item number 25, both the parties are present, my lord.
Huh? 25.
25, my lord, on 22nd, my lord, kindly fix it.
Oh, not in this way. Every matter, not today. Okay, not today.
22nd.
Kindly fix this matter on,
Huh?
Kindly keep this matter on the 25th, your lordship. I mean, 22nd, Tuesday, your lordship.
Okay, করে দিন 22nd. ঠিক আছে, that's all.
25.
সব বাড়ি করা।